May we have appearances, please? Orientale versus Jennings.
Good afternoon. My name is David Kott. I'm a lawyer with McCarter and English, and I represent the Amicus Curiae, the New Jersey Business and Industry Association, which is the largest business association in New Jersey. Its members employ over 1 million New Jersey residents. The plaintiff is a 34-year-old investment banker from New York. He's a partner at Goldman. He's at one of the large casino hotels in Atlantic City and has a diving accident at the pool. He becomes a quadriplegic. His lost wage claim is $14 million. His life care claim is $8 million. He has catastrophic pain and suffering. The jury finds the defendant 100% liable and awards $500,000. And the reason they do that is because he's an African American. Or the reason they do that is the jury consciously decided to ignore and not follow the judge's instruction on damages. Or the reason they did that is because when they deliberated, they went on the internet and found an article that said in 5 months there'll be a cure for quadriplegia. In Fertile, this court said the reason why remittitor should be the highest amount is we want to tamper is the word, tamper the least with the verdict. I would hope that everybody in this courtroom, the justices and the lawyers, could agree in my example, that's a verdict we want to tamper with the most. We don't want to give 1 ounce of deference to that verdict. Let me put it in legal terms. Rule 4:49. That verdict clearly and convincingly is a manifest injustice. Baxter. That verdict shocks the judicial conscience. Cuevas. That verdict is plainly wrong. So we believe the court should change the current law, and both for remittitor and for additor, make the standard not the highest for remittitor, not the lowest for additor, but rather a reasonable amount that a jury would award based on the trial record. And there is a tremendous practical advantage to that. If the trial judge, after sitting through an entire trial, puts a number on it that's the reasonable number, and the plaintiff's lawyer has to go to her client and say, this independent judge thinks this is a reasonable number, and the defendant has to go to his client and say this independent judge thinks this is a reasonable number, the chances of that case settling at or near that number is very high. And this court has a couple decisions that settlement is to be encouraged and advances the public policy of this state. Finally, on the issue of should both parties be allowed to consent, let me try it this way. If you keep the standards the same, highest for remittitor, lowest for additor, and now you add to that both parties must consent, as a practical matter, you've done away with additor and remittitor. And the reason I say that, let's deal with additor as an example. If you keep the standard at additor, the lowest amount, and that now the plaintiff's lawyer can object to that and get a new trial, she's going to object every time. Indeed, I think it would be legal malpractice per se for a plaintiff's lawyer to accept an additor at the lowest amount a reasonable jury could award when she has the option of saying, no, I want a retrial. So for that reason, we believe on who has a right to consent, the law ought to remain the same. In remittitor, only the plaintiff, and in additor, only the defendant.
Mr. Kott, wonder if you can help me with something.
I'm glad to try, Your Honor.
We logically went beyond Additor toward the presentation that we have today based on the issues that both Additor and Remitter present so that we could explore what to do in this case and what to do with the larger question. And we're trying, as you aptly just put, to find the right spot, to be practical, to foster resolution of these cases. So we brought in able parties and amici to come and speak to us, and they start representing their members at different spots. My concern is, in doing so, we may have left out an important group of objective, likewise gifted people who try to settle cases every day. I'm thinking of our civil PJs up and down the state, whose daily efforts we might gain some insight from as well. Is there a sensible way for us to engage other voices as we try to find the right spot, much of which relates to our rulemaking capacity?
Yeah, and I'm going to go over to my friend Mr. Gurn. That one I had not really thought of as he had not thought of. It seems to me, and I don't know the answer, Justice Albin, whether this is substantive law or rulemaking. I do not know the answer to that. I'd have to look at. But it seems to me that in this court's jurisprudence, you've always treated it as substantive law. You have a lot of cases, particularly with Remitter. The appellate division has something like 5 or 6 with Additor. So it seems to me that this court has always treated that as substantive law.
So let me stay with that for a second. Were we to say the highest, the lowest, or the most reasonable amount
Right.
with an eye toward resolution and efficiency is a question of substantive law and not necessarily one of how to foster settlement of cases?
Well, the answer is I think it is substantive. The result might be that it has an impact on settlement.
Isn't it substantive for 2 reasons? Number one, we're dealing with the right to a civil jury trial. And the question is, what is the appropriate function of a judge and a jury within this sphere? Then we're also talking about alterations of the common law, which has governed this area of the law for more than 200 years, probably 200 years, at least 200 years. I don't know of any state that has ever decided this issue based upon its court rules. Are you?
No, I'm not aware of any. And that's what I was saying. This court has treated it as common law. You've got a lot of cases that deal with Remitter, shock the conscience, 449. You've got a lot of cases that deal with that.
Please finish.
Go ahead.
Your proposal sounds like, and State Bar is quite similar to yours, sounds like a settlement effort after the trial has been resolved.
Well, no, it's more fundamental than that. Because my problem with the highest and lowest, coming back to the Atlantic City case that I talked about, is in some ways, on the highest, it's because we want to give credit to what the jury did. But the jury did something that shocked the conscience. It may be a lot more than they simply got it wrong. It might be that they, and that's why I used the hypo I did, they had an ill motive.
So why don't you, so your reasonable amount, the one that you argued, which is the one that is most likely to bring both parties together, would be the most efficacious and probably logical approach, particularly if you permitted both sides the right to consent or object, correct?
I'm not sure. If you do the reasonable amount, the issue of whether both parties should be allowed to consent is a much less important issue. You still may have to call it and decide it, but nobody's getting hurt too badly once this court tells the trial judge, instead of highest and lowest, you're going to do the reasonable amount.
Well, isn't that essentially the most, if the goal is settlement, that settles the case? I mean, if there's a reasonable amount thrown out there, and there's no objection, or there's no objection by either party, they've just settled the case.
Correct.
So, does that work effectively to resolve cases?
Well, I think it would, for the reason I said. I would report to my client, as would every lawyer, that Judge Smith or Judge Jones in Middlesex or Camden County tried the case, heard the entire record. We had a post-trial motion, and she said a reasonable number is X. That's got to have a big impact on both plaintiffs and defendants.
Even if it didn't settle it, it would probably put it on the road to settlement. It might not be that number, but the parties would be circling around that number.
Let me ask you, if you would, to respond. Mr. Gurn made an argument for plaintiff having the right to object on both, and as to why analytically he sees the two as different. Would you respond to that?
Sure. And there's 4 responses. The main response is what I came back to before. You only get to the result that Mr. Gurn argued for if you're going to give some homage to the verdict in the high verdict situation. That is, you don't want to tamper with that verdict. But that verdict, I'll switch the hypothetical, Mrs. Smith on the escalator at one of the casino hotels sprains her ankle, and the jury awards $50 million. And the reason they did it is the jurors think gambling's immoral, or they did it because during deliberations they went on the internet and saw the revenues of the casino. So I throw out entirely giving any deference to that jury verdict, but Justice Patterson, there are 2 or 3 other reasons. Number 1, you've already disturbed the verdict. As soon as you've granted the remitted or added, or indeed you might take the verdict away entirely.
Let me be more specific in my question. Mr. Gurn viewed, and I'm speaking for him, he can articulate it I'm sure better than I can, but he viewed additor as analytically different from remitter because plaintiff has met her burden.
Oh, I see.
See, and therefore plaintiff should have the ability to object to the additor, object to the remitter. Defendant only gets to object to the additor. I'm sorry, yeah.
Not my response, and I don't mean this flippant,
Yeah.
she hasn't met her burden much. $200 verdict, this case is the example. Jury clearly discarded her testimony.
Do you see these two as mirror images of one another?
I do, and I would say this. This court, and I'm being factual, I'm not being judgmental, this court has typically often had very pro-plaintiff, pro-consumer holdings. Henningsen, Bashada, Adelise. What this court has never done is on these procedural devices treated plaintiffs and defendants differently. This court has been completely neutral. The scales of justice have been like this. Same number of jury challenges, same number of days to file a motion for a new trial, all throughout the rules, all throughout the procedural common law. Part of the reason this court has credibility, despite some somewhat liberal decisions, is that it is a fair court, and it's perceived, particularly by my client, which is the business community, as a fair court. As soon as you adopt the arguments made by the plaintiffs, you're doing what some other states do, which is now the rules are tilted and the scales are not evenly balanced. So I know in the first argument which I watched, defendant's counsel talked about fairness. It is fairness, but it's fairness that's more important than good old-fashioned high school fairness. It's for the credibility of the court.
Anything you'd like to add?
We thank the court again for allowing us to appear as an amicus.
Thank you.